Assalamu alaikum and welcome back to Just Law on IQRA TV. This is the second part to our show. It's a live show. The number that you can call on will be appearing at the bottom of your screen. Just before the break, we were discussing the position of those who have overstayed in the United Kingdom and what they can do, or in what circumstances they would be able to regularize their stay in the United Kingdom. We looked at the position of those people who are single and the length of time that they need to reside in the UK before they become eligible for some kind of right to stay in the United Kingdom. So we've done that already. Now I want to look at the position of those people who are intending to get married and whether the marriage to someone in the United Kingdom can to some extent assist them in trying to regularize or to sort out their stay in the UK. Although we're talking on that subject, if you've got a question on any aspect of the law, immigration matter, etc., there's a number that appears at the bottom of the screen, so do pick up your phone and give us a ring and we'll have a discussion about that. So we've already looked at the difficulties that single people face. Now, if somebody has the opportunity or the circumstances have come up whereby they can get married, potentially that can assist with an immigration application. And I say potentially because under the immigration rules, the mere fact that you've got married to somebody who is a British citizen generally is not enough for you to be able to get the right to stay in the United Kingdom. There are very, very limited circumstances in which the Home Office or the Tribunal would be prepared to grant you the leave that you're seeking. But we'll look at that in greater detail after we've taken our next call. Hello, Assalamu alaikum.
Walaikum assalam. I've got three questions regarding spouse visas.
Right, okay, yep, sure.
Okay, my first question, sorry.
Yeah, sure, fire away, yep.
Okay, yeah, my first question is, are bank statements which are printed by the bank, the branch, are they acceptable for visa application?
Okay, so shall I, it might be easier if I just answer that, answer them as we go along. The statements printed by the branch are acceptable. Generally speaking, you will need to get the bank statements stamped by the branch. The safest course is to get them stamped by the branch. Some branches are reluctant to do that. What I tend to say to people is, look, if they say no once, go back the next day, speak to somebody else. Generally, if you're persistent, you'll manage to get them stamped. But generally speaking, they are definitely acceptable, but do get them stamped by the bank. Okay. Let's see. I do apologise. I think that call has been cut. Brother, if you just call again, we'll look at your next questions. Hello, Assalamu alaikum.
Hello, Assalamu alaikum.
Ji walaikum salam. Thank you for calling. What's your question?
Yes, I just want to ask a question. I'm making the application. I have an appeal. My spouse's application was refused on the basis that he has used deception previously.
Okay.
Is this something that we can get around on an entry-clearing spouse application?
As it's a spouse application. All right, okay. Now, is it just the case that the allegation is that deception has been used once previously in a previous application? Is that the problem?
Yes, he made a separate application unrelated to this entry clearance application.
And deception had been used for that. Thank you very much for your call. I'll address that now. It's a very interesting call, but we're sort of rushed with calls. Let me just take the next call and I'll come back to this. Hello, Assalamu alaikum.
Walaikum assalam, sir.
Ji bhai.
How are you?
Yeah, alhamdulillah, good. How are you? You okay?
Yeah, okay.
Mashallah.
I was just to discuss my immigration matter.
Yeah, okay.
Okay. I'm living in this country from 2006.
Yep.
Okay, I entered this country illegally.
Yep.
And I'm married to a girl over here.
Okay.
Who was human trafficked over here.
Okay, all right, okay.
Okay. And unfortunately, the NRM gave us a ground decision negative on her case.
Okay.
And I applied from 2008. I'm trying to get human right basis.
Okay.
Just to give me right to live in this country.
I understand. Yep. Okay.
And now we have a kid who's born in this country.
Okay.
And he's 2.5 years old.
Okay.
And we are Indian nationals.
Okay.
Okay, but unfortunately, we don't have our passport with us. We can't register our child with the Indian embassy.
Okay, okay.
So now he's a stateless.
Okay, all right, understand, yeah.
So I want to apply for him stateless, so I want to know what the situation is.
I think the best option you're going to have is, because you can't get stay based on your relationship with your wife, it's the best option would be to register your child as a stateless person. The advantage of that is once the child has been in the UK for 5 years, potentially the child qualifies for a British passport after 5 years. The key point about a stateless application, especially where the parents are from India, is you need to produce some kind of evidence that you are unable to obtain. Now, what the leading case on this says is that the embassy may not be prepared to give you confirmation that the child is not British. Yeah. So the case, or the judge dealing with the previous case, acknowledges that fact, that it's unlikely that the embassy will give you a letter confirming that your child is not British. So what is the other evidence that you can submit? On that, I can say two things. One is, in my experience, the evidence is you can do an affidavit saying, look, I made an appointment on this day. Keep confirmation of when you made the appointment, confirmation of who you spoke to, and do an affidavit explaining, look, this is what's happened. If somebody accompanied you, they can do a statement as well, along with the proof when you've gone to the embassy. So you make a statement along with any other evidence that you can produce in terms of appointments, in terms of evidence of travel there, etc., and confirm that, look, we've not been able to obtain evidence from the embassy. So that's one point I can make. The other is the Home Office has actually produced guidance on this, which is about 1 month old. So it's probably worth looking at the latest guidance on making stateless applications on behalf of somebody. It's worth looking at that. Even if you go onto the Home Office website, and even if you Google for statelessness application, Home Office guidance, it should come up. There's a new guidance which came out about a month ago, which explains what kind of evidence will be acceptable when you make this application. But essentially, you're not going to be able to get anything from the embassy. Your evidence is going to be your affidavit, somebody else who's assisting you, their affidavit, and some surrounding evidence. That's all it's going to be.
You know that nobody is going to assist us to go to the embassy, no evidence. But the thing is that I am getting in contact with the embassy, emailing them what are the requirements and whatever it is, and I got one response only, and I got an appointment. So how do I make that affidavit?
Okay.
Like, so I can print out the email.
So you print off the email. That's your evidence. You're not saying to the embassy, I want my child to be registered as Indian. That's not the question. What you're asking the embassy is to confirm whether the child is an Indian national or not. That's just at the moment, is the child an Indian national? Now, apparently, Indian nationality law, the way it works, is that if the child is born in the UK, the child is not born an Indian national until the child is registered. And you're not obliged to register the child. The law does not require to register. We just need confirmation that as of the time you make the application, the child is not an Indian national. And I think that's all you can do. Affidavit, evidence of your appointment, etc. Even if you go down to the embassy, take photographs of when you go down, and we can look at that. Thank you very much for your call indeed. Sorry to have cut you off short. We do have a number of calls waiting. We'll take the next call. Hello, assalamu alaikum. Hello.
Hello, assalamu alaikum.
Ji walaikum assalam. What's your question?
My question is regarding spouse visa. So I got cut off a bit earlier on.
Right, no problem. Right.
So my question was, a part of the VA4A form has to be sent to the, like, so say, for example, Pakistan, to be signed by the applicant.
Sure.
And then does she scan it and return it back to me, or do I need the original one?
The practice,
does she need it for biometric?
The practice of the Home Office appears to be that even if you submit the form without the signature, then they don't seem to be objecting at the moment. Even if you submit that form without the signature to Sheffield, it's the online form which you print off, which requires the signature, not the appendix form. The appendix form doesn't have a signature on it. It's the online form which is printed off and is meant to be signed in 2 places. what I've noticed over the last 6 months is that if you submit that to Sheffield without a signature, they don't raise an objection about it. But I mean, it's up to you. The other option is, if you want to be very cautious, ask your whoever's in Pakistan, wife, or if you're calling on behalf of somebody else, ask the partner in Pakistan to sign it, scan it, and send it back. It's absolutely fine. There's no issue about that at all. There's no issue about it. So,
we should need that form for the biometrics as well.
They do. I mean, my view always was it's not necessary, but apparently it's better if they take it, because what's happening at the visa centre is that they're asking for two things: the appointment confirmation letter and the application form. So they're asking for both. I don't know why they want the application form, because that's actually then submitted in Sheffield, but they're asking for that. So to be on the safe side, send both documents. Because at the visa centre, otherwise they'll just create problems. So send both documents, get them to sign it, send and take both along. But in terms of the document that you submit here in Sheffield, in my experience, even without a signature, there's no problem with it. If you want to get a signature, get it signed, scanned, and back again. Okay. Thank you very much for your call. Thank you. We'll take our next call. Hello, assalamu alaikum. Hello.
Hello.
Hello, assalamu alaikum. Thank you for calling.
Assalamu alaikum.
Wa alaikum salam. Thank you for calling. What's your question?
Yeah, my question regarding spouse visa.
Okay.
I got spouse visa in 5 years old.
Okay.
And my first I got 2.5 years.
Okay.
Then I want to apply for another 2.5 years.
I understand.
The problem is my wife is pregnant.
Okay.
So she got the first 6 months paid, then next 3 months half paid or statutory paid.
I understand.
And the last 3 months,
I
we're not going to get any payment, but I have to pay her pay slip to show our economical situation. But she didn't get any pay. So how can I?
Okay, there is a concession within the immigration rules where you. Your wife is on maternity leave. The concession is this: that what the Home Office is prepared to do is look at the income prior to her commencing maternity leave. So if she's on maternity leave, obviously her income will drop. So what the Home Office has done is that the Home Office has drafted the rules in such a way that for her, the income that's looked at, it's not the 6 months before the application, it's the 6 months before she started maternity leave. So that would help you, because you're not looking at the reduced maternity leave income, you're looking at the full income before she commenced maternity leave. And then obviously if you're working, your income as well. So that's how you look at the income, where you have somebody, one party who is on maternity leave. You don't have to look at, you have the option, if somebody is earning enough during their maternity leave, you can count the maternity leave income, that's not a problem. But in my experience, because of the drop in the income, it does cause a problem, in which case you show the income 6 months prior to commencing maternity leave. That's what you do. Okay, hope that helps. Thank you very much for your call. We'll take our next call. Hello, assalamu alaikum. Hello. Hello, assalamu alaikum. Hello. Call dropped. Okay, that gives me the opportunity to answer the question that came in before, which is where somebody's used deception in an application. The application's been refused. Now they're making a spouse application. Now, is the fact that they used deception before, the applicant used deception in a previous application, it could have been a spouse application, it could have been an unrelated application, but the fact that they used deception before, will that be used against them in the current spouse application? In general terms, no, it shouldn't be used against them, because in a spouse application, the rules basically state that previous deception matters will not be looked at. But there's a very limited exception to that, and I'll try and deal with that after I've taken the next call. Hello, assalamu alaikum.
Walaikum salam. Sir, I have a question. I came in UK in 2011 April as a student.
Okay.
I did my degree and masters in marketing, and after that I applied for Tier 2 visa, which I got in 2015. So in this year I got married as well. So I applied for a spouse visa, which is FLRM.
Okay.
I went to the Solihull office for same-day service, but they refused my visa. They put the objection on that I appeared in TOEIC exam twice.
Okay.
And I know I appeared in TOEIC, but I never used that certificate because I never got the certificate.
I understand.
So, but they gave me my the biometric card.
Yeah.
They gave me back. They said, we refuse your visa, but this Tier 2 is still, you can stay here till when your visa finishes.
Okay.
So, but I went to the court, I applied for the appeal, but I didn't receive any court date at the moment. Firstly, I don't know why they refused on the basis of TOEIC, as I never used it. And secondly, I want to know, do I need to extend my visa again? Because my visa is expiring next month, and I didn't receive any court date at the moment. So what shall I do?
All right.
Anything?
Okay. First point, for your TOEIC exams that they're talking about, the 2 previous TOEIC tests that you've taken, what is the Home Office saying about the results? Are they saying the results are invalid, or are they saying the results are questionable? Which category is it in? Do you know?
When I went to the Solihull office for same-day service, they called me for interview. At that time, I totally forgot that I appeared in TOEIC. I refused them. I never appeared. I said I appeared in different exams, but I'm not sure which one, because I appeared in City and Guilds and IELTS as well in UK.
Okay. Do you have any children at all from your
No.
marriage? All right. Okay.
No.
Now, when you say you appealed against it,
yes,
where did you appeal?
They gave me 14 days for appeal.
They gave you
14 days to appeal.
To the Immigration Tribunal?
Yes.
Okay. And you still have the existing Tier 2 visa at the moment, don't you?
Yes.
When did you appeal?
I appealed in September.
Or September. So it's only been recent, right?
Yeah, recent.
Okay, all right.
I went in September for a same-day service.
Okay, all right, okay. I'm not sure you are actually eligible for an appeal, to be quite honest. Generally, the rules are that where you are refused a visa, but you still have your previous visa, that's still extant, it's still valid. You don't normally qualify for a right of appeal. So
they gave me 14 days for appealing in the court.
It just sounds unusual to me that they've given you paperwork for an appeal. Because in my experience and my understanding of the position is that you do qualify for an appeal where you've submitted an application and now you don't have any visa left. You qualify for an appeal in that situation. But where, like in your situation, where you're refused a variation of your leave, but you still have your old visa continuing, that's not been curtailed, you don't normally qualify for an appeal. So I'm a bit surprised that a caseworker has given you a right of appeal. Chalo, well, let's wait and see what happens with that appeal. When does your Tier 2 visa expire?
In January.
In January. So by January, you will know what the position is anyway. If the tribunal comes back to me and says, look, you've got no right of appeal, then you know, okay, in January, you need to apply again. And when you apply in January again, what will happen is that the reality is, if this appeal hasn't taken place, if you apply in January again, at that stage, if the application is refused, you won't have any visa left. Okay, then you will definitely be eligible for a right of appeal at that stage. And I think that may well be the best way to challenge it. In my experience, the people who've fallen into this category where the Home Office is alleging you've used a proxy test taker to do a test, you're not, this is all fraudulent. In my experience, when you get to the tribunal, you generally win because the Home Office has no evidence specifically against you. In my experience. But I think what you do need to look at is first of all, let's just wait and see what happens with this appeal that's been submitted. If the tribunal accepts it and it carries on, fine. If not, I think you're going to have to resubmit your application in January and get a inevitable refusal and then appeal against it. Because in my experience, what should actually happen is, although you don't qualify for a right of appeal, you're able to submit a judicial review application against that decision. That's what the normal course of action is. It's the judicial review, which is the way to challenge that decision, where you get an adverse decision whilst your old existing leave is pending. It's normally challenged by way of judicial review. So I'm surprised the caseworker's given you the right of appeal. I think it's a mistake, to be quite honest, unless I'm wrong.
And they gave me the passport. I had 2 passports and the biometric card as well.
Give it back. They'll give it back.
Along with that, they gave me a letter in which they said you have 14 days to appeal against this decision. So I was confused as well. Even though I discussed with my friends and everybody's like, how come they refused on this basis and they gave you this kind of thing in a year?
Yeah, it's unusual. I mean, passports they give back. The reason they give back the passport and the biometric card is they haven't cancelled your tier. They haven't cancelled your tier 2 leave. I think, brother, the best thing is, it's slightly unusual. Let's see what happens in the next couple of months. If you're not sure, give me a ring. We'll have a discussion about it. But let's see. You've got your appeal pending. Let's see what happens. Okay, thank you very much for your call. Sorry, I've had to cut you short. Okay, so I spent a lot of time on that call. Apologies to those people who are calling in and holding on. If you do want to call back, please do call back and we'll try and deal with your query. Just then going back to the matter I was discussing about where somebody is alleged to have used some kind of deception in an application, in a previous application, and then that application obviously has been refused. They're now making a spouse application, and will that previous deception be used against them? And as I said, generally speaking, in a spouse application, your previous conduct shouldn't have a bearing on your most recent spouse application. So even if you've lied, for example, about your bank statements, you've submitted fraudulent bank statements before, let's say, for example, in 2016, you've submitted a spouse application, submitted fraudulent bank applications. 2017, you make a fresh application that's refused. They shouldn't use your previous conduct against you. So that's the position, generally speaking, with spouse applications. Now, there is one matter that you need to be aware of. It's a slightly different category. It relates to those people who have come to the United Kingdom, who've overstayed and then done something else wrong, such as used deception in an application, such as failed to report, such as made an application in somebody else's name, used a different identity, etc. Now, if you fall within that category, where you've overstayed in the UK and done something else which is wrong, they look at the something else that you've done wrong as an aggravating factor. If you fall within that category, there is the possibility that even if you later go back to your home country and apply for a spouse visa, there is a possibility that what they will do is still refuse the application based on your previous conduct, using a rule which is within the immigration rules, which basically states that if you have previously contrived in a significant way to frustrate the intentions of the immigration rules, a bit of a mouthful. Basically what it's saying is, if you've tried to, if your conduct has been such that you've broken the immigration rules in a serious way, you've really, not just overstayed, you've done something which they consider to be an aggravating factor. If you've done that, then even if you go back to your home country and make an application, we can still use that against you. And what I am now seeing in a lot of applications is that being used to refuse the application. So if you look at the situation where somebody has overstayed, they decide, look, I've got to do the right thing now. I'll go back to my home country, make a proper application, make a paid application. I'll be upfront. I'll explain, look, I did overstay, I did X, Y, and Z, but now I'm making a proper application to join my British citizen spouse in the United Kingdom. they tend to go back thinking the application will be successful. But what the Home Office can do, and this is something you always have to bear in mind when you make a decision to go back to your home country, what the Home Office can do is look at your conduct whilst you are in the UK. If you overstayed in the United Kingdom and there were aggravating factors, in all likelihood, the Home Office will refuse your later application. You will get a right of appeal. The judge will then have to decide whether your circumstances are such that despite your conduct, if it's accepted, despite your conduct, you should be granted a visa to join your spouse in the United Kingdom or not. So that's the position with previous conduct and future spouse applications. So that hopefully answers the question that was raised before we had a series of questions coming in. Unfortunately, that does bring us to the end of the show, and what we'll do next week is carry on with the topic we were discussing before, the position with overstayers and how they can regularize their stay. We'll look at that next week, but until then, hopefully I'll see you next week, but until then, Assalamu alaikum.